Hi, this is February 20th, 2020 here, and I'm Steve Dale, and we're here to talk about special needs trust with a focus on mental health, okay? So part of this, as we go through this program here, is the reason for this program is to prepare folks before they begin their planning with their attorney. What we've found is that clients who attend this program are able to be more engaged when they're actually involved in putting their trust together, and there's no way we can answer every question, but ideally we're going to cover a lot of things that will really help you in the planning process about what is a special needs trust, what does it do, how does it affect public benefits, something really important. We're going to talk about choosing a trustee here, and then we're going to talk about the entire process. I want to thank you for watching today. The other thing that I'll mention is that a lot of this comes from our planning guide called the Achieving Independence Guide. If you email Amy, she'll send you a link to the existing guide, but we're actually in the process of updating this. And so we'll just see, depending on when you watch this and when you send the email, we may be able to send you the updated guide. Once again, the point of the guide is to help folks work through the planning process here and make it a little less daunting. So let's begin a little bit here. I'm going to start off with one of my favorite subjects, which is myself, of course, here. And this picture that you see here, there's two important things. One is, you might notice that building there. That is Agnew State Hospital, which at this point is rubble, probably where it belongs here. But the significance of this is that my family came from 3 generations of workers in the state hospital system, including myself. So the picture up in the corner, the fella there with the bald head, that's my father. He worked as a psych tech for 40 years at Agnew's, Napa, and Patton hospitals. The fella holding the baby down there, that's my grandfather. He worked at Agnew State Hospital running the hog farm and the orchards for 35 years. That dashing young man there with the mustache, that's actually me a few years ago. I worked as a psych tech for 17 years. I worked at Napa State Hospital, Patton State Hospital, and Sonoma Developmental Center here. And that little kid down there, that's my son, and he did not follow the family tradition. He did not become an institutional nurse, okay? Now, the point of this is how we got into this. And one thing about our office is it's very unique. All we do is special needs trust. Now, occasionally, we might get somebody in who doesn't have a loved one with a disability, which, quite frankly, very much confuses our staff because that's not the norm. But most of the folks we work with usually will have a loved one with a very significant disability. So this is where we've had our focus. Part of this, just finishing this up, after I finished up as a nurse, I had a really bad experience at Napa State Hospital. Could you imagine that? Here, and ended up working for a civil rights organization called Disability Rights Education and Defense Fund, where we used to get fairly large settlements for a lot of folks dealing with, mostly with violations of the ADA. And they would immediately lose their public benefits. Now, when I went to law school, that meant little or nothing to me, or nursing school as well. But one day my directing attorney told me I was going to learn about all these special needs trusts. And at first I was really resistant, but as I got into it, I found that this was an area I really enjoyed because not only was it an area that worked with persons with disabilities here, but also part of putting together a well put together trust is having a trust that's going to do more than preserve public benefits and will serve as a care management tool as well. We're going to cover that quite a bit. As we go through this, there's going to be pictures that'll flash up of the different chapters as they are now in the Achieving Independence Guide here, which will send you a PDF copy if you may email Amy, and then it is in the process of being updated. The only thing wrong with the current guide is the numbers are slightly off. Okay, so starting off with Chapter 2. What we're talking about here is defining the challenge when we're doing a special needs trust. When somebody's asked to describe the purpose of the special needs trust, the typical answer is to protect eligibility for public benefits. Focusing only on preservation of benefits really fails to meet the big picture. Our true objective should always be to maximize quality of life for a person with a disability. So let's start off introducing you to Kathy. And for some of you, this won't be hard to imagine. So imagine that you have a daughter named Kathy who has schizophrenia. Kathy's likely to need some level of assistance for the rest of her life. Something we should keep in mind, no matter what the disability is, some folks are going to need an enormous amount of help. Some folks are able to be their own self-advocates, and then we'll have everything in between. So one thing about folks, whether it's mental health or developmental disability or physical disability, they're all individuals, and we have to work with them based on them all being an individual. So you come to the estate planning attorney to provide for her needs in the event of your incapacity or death. Kathy's otherwise healthy and likely to live 70 years or longer if you were to pass away tomorrow. So what's our challenge? We're going to go through a segment about the basics of public benefits, because it's hard to talk about a trust that preserves benefits if we don't talk about benefits. But the question is for the folks in the audience, which, by the way, the camera's not on you, how many of you think our public benefit laws will stay the same for the next 70 years? We didn't get a response. Okay, so they don't think it's going to stay. I'm not sure it's going to stay the same for the next 7 months, right? So let's think about it. Social service systems are going to change. I will say, and I think this is universally true, California's commitment to mental health is, what's a good term? Disgusting, right? I just got back from Texas, of all the places here that have far superior programs than we have in California. Do we have a little pride here? But we didn't put our money into mental health here in California. But maybe things will get better. And part of this, as we're working on support systems, is it is going to change over time. When my father was working on deinstitutionalization here years and years ago, once again, they poured a ton of money into mental health. But unfortunately, in the 80s and 90s, that waned. Her condition may change. These folks are not static. She may get better. She may get worse. There may be a treatment that really assists her. That assistance might help for a long time. It may help for a short time. We just, part of this is we're in for the long game. And we have to realize that these are not static people. They change. Her advocacy system may change, especially when that advocate parent or loved one passes away. And so part of what we're looking for is that we can never replace the parent. Of course we can't do that. But on the other hand, part of this is a lot of these folks do need someone to help advocate for them and make sure that they're free from abuse and neglect. Attitudes may change one way or the other, and we're seeing that a lot with mental health. We're seeing that NAMI, which is a wonderful organization here, has really worked hard to try to diminish the stigma of mental illness, and there's been a lot of gains in that area. On the other hand, with the gun situation and everything going on, in some cases people are more afraid of folks with disabilities. So attitudes do change, good and bad. The amount of resources she needs may change. One of the hardest questions I have, especially when you're talking about a 17-year-old, is how much money should I put in my child's special needs trust? And the answer is, how would I possibly know? Because there are so many factors out there, since we're supplementing services here that provide for Kathy's care. If the services increase, well, then maybe we need a little less. If services get worse, which would be kind of hard for me to imagine, then we need more, right? So here, her trustee options may change, and that's going to be an area that we're going to talk about quite a bit. I've been doing this for 30 years, and the folks that I used as trustees 30 years ago don't even exist for the most part today, right? And so one of the things we're going to talk about is how do you keep that continuity of having a trustee who's going to be there for you. Now, the other thing when we're talking about planning, and I want to introduce this fellow who had a lot of influence on my life, a fellow named Ed Roberts here, is dealing with what happens if you become part of the disability community. What happens if you're not able to be that advocate, or what happens if you need assistance yourself? As Ed Roberts used to say, the disability community does not discriminate. It will accept any of us at any time. And the point of that is this: a good estate plan shouldn't cover just what happens when or if I pass away. But the other thing it should cover is what happens if I become incapacitated. Who's going to be in charge of my things? How am I going to give them instructions about how to allocate what resources I have between myself, my spouse, and my child with a disability? And I might even have other children that have needs, or I may have other things like churches and other causes. Part of this is in good estate planning. It should also cover, in case if you're incapacity, what is the trustee supposed to do? Another way to look at this, and this comes from a book called Living Trust. Living Trust is not even in print any longer here, and it's not really a book about special needs trusts. It's a book about a philosophy of estate planning, but their definition of estate planning is that I want to provide for myself and my loved ones during my lifetime, and upon my incapacity or death, give what I have to who I want, the way I want, when I want, and if I can, save every last fee, tax, or court cost possible. One thing a good estate plan should do here is make sure that all of your assets are marshaled, but it's also not just death planning. It really, sadly for many of us, we may have some sort of a severe incapacity ourselves when, before we pass away. And those are really difficult things to deal with, but they need to be dealt with. So part of this is striking a balance. Many families that have a loved one with a disability are balancing their needs with the needs of their loved one. And that's something that actually never ends. A good estate plan should reflect the values of the grantors, those are the folks setting up the trust, by leaving instructions to guide the trustee about what factors to consider in maintaining that balance. For instance, if you were to have a stroke, a well-written estate plan should provide the trustee with clear instructions on what to consider when providing for your needs as well as the needs for the rest of the family, including your child with a disability. So let's go to the next segment, which is a primer on public benefits. Now, on the Achieving Independence YouTube page, we have all sorts of videos that go in much greater depth than I'm going to, but I'm going to run through this as fast as I can. So really, when you're talking about public benefits, there are actually two types of public benefits. There are benefits that are based on need, and those are things like SSI, Medi-Cal, food stamps, legal aid, utility payments, that sort of thing, and HUD and Section 8. Now, what's common with those programs is you have to show a need based on disability, but you also have to have limited income and resources. They're a form of a welfare program, okay? So, on the entitlement side, we have programs like Social Security Disability Insurance, Childhood Disability Benefits, which we're going to spend a modest amount of time on, Medicare, and special education. What's common with those programs is that you need to show a need based on disability, but there are no income or resource limits for those programs. You could literally win the lottery and you would still get to keep those benefits. Let's look at it a different way. Our needs-based program here for cash is Supplemental Security Income, or SSI, which is where we're going to spend the majority of our time. But tied to that is Medi-Cal, our medical program. On the entitlement side, there's two similar programs. One is Social Security Disability, and the other one is Childhood Disability Benefits, and tied to that is Medicare. For many of our clients, eventually they may get all four programs, and they interact together pretty well, sometimes not so good, but it's not uncommon that we'll be getting multiple programs, and it can get pretty confusing. So let's start off with the granddaddy of all the programs, Supplemental Security Income, which is administered by the Social Security Administration. It's actually not Social Security. SSI is a federal program administered by the states and is based on showing the sufficient evidence of disability and financial need. It's intended to pay for the beneficiaries' food and shelter and nothing more. Now, the way I like to say it, and we'll get to this in a minute, is it's really for food, Clothing we don't count any longer, and shelter and nothing more. And I'll go through why the clothing thing matters. Now here's the shocker here. If you're getting SSI, usually the maximum amount of SSI you get is $943.72. Now there are some exceptions. So you're supposed to live in California on $943.72. Good luck with that, okay? I think I say every day I would never want to be one of my own beneficiaries. How these folks can live on this kind of money is just beyond me. But that's what we allocate to these folks. To qualify, there's a three-part test. The first test is you have to meet the definition of disability. The second test is an income test that determines how much you're going to receive. And the third test is a resource test that determines your eligibility. So let's go through these one at a time. So, what is the definition of disability for SSI? A benefits recipient must be a person who is under the age of 65, who is unable to engage in what's called substantial gainful activity because of a medically determinable physical or mental impairment that's expected to last a year or longer or end in death. In 2020, the SGA amount is $1,260. This is an important concept here because it's not merely having the diagnosis of a mental illness or autism or even Down syndrome or something like that. That will get you through the door, but in order to actually get the benefits, what they're really looking at is, can the person earn more than $1,260 a month consistently? Now, there's a lot of bizarre things in public benefits. Once we prove that they can't earn more than $1,260 consistently, there's programs where they can earn up to $60,000 a year and still stay on benefits. I know that doesn't make any sense, but you just have to kind of go with it. By the way, a really good website for these kind of issues is a website called disabilitybenefits101.org or db101.org. Okay, so once again, there is a kind of a functional side to this, and it's not really so much the diagnosis, it's whether or not they can maintain a job and earn $1,260 a month consistently. So the next is an income test that determines how much you receive. So the first one that most people know is when you're on SSI, any cash you get from anywhere will reduce your benefits dollar for dollar after the first $20. So let me give you an example. Let's say you say, I don't want to do one of these special needs trust things. I think what I'm going to do instead is I'm going to go out and buy an annuity and leave my loved one $100 a month to do whatever they want. If they're on SSI, here's what Social Security says. Great. We don't have to give them all that money. We won't count the first $20, but we'll reduce the benefits by $80 a month. So the first thing on being on SSI is you cannot give them cash. And that's a pretty strict rule. The second rule is if you earn it, you lose $1 for every $2 you earn after the first $65. So let's say in the month of February you earn $265. What they do is they don't count the first $20 or the first $65, but what they'll do with the remaining $200 is that they'll let you keep $100 and they'll reduce your benefits by $100. Now you're $165 ahead. And the other thing with this is that working oftentimes is the road to independence. So, once again, if you're looking at whether or not your loved one can work, the DB101 website is a wonderful website to go to. This is the hardest, this next one is the hardest one to understand, so I'm going to do my best. Let's say to your child that they can live in your house and eat your food and you're not going to charge them rent. Then SSI is going to say, great. And let's say the fair market rent for your area is $1,000 a month, which is in California, that's not very high, right? So, which is certainly more than what they're getting. So in that case, what Social Security is going to say is, great, we're going to reduce your benefits by $281. Now the question is, where did they come up with that number? Well, here's the thing. This comes back to the clothing thing. The federal part of the SSI, so we're in California, so we have a federal amount and a supplement. But the federal amount is literally 1/3 for food, 1/3 for clothing, which we don't count any longer, and 1/3 for shelter. So getting back to this, if you're providing shelter, and let's say it's worth $1,000 a month, which would be a little hard for your loved one to pay on $947 a month. Only the federal government can do that, and they don't do it very well here. But, with that, what's going to happen is they're going to reduce the public benefits by 1/3 of the federal part of the SSI plus $20 just to confuse us all. Okay? And that's where that number comes with. By the way, the biggest issue we deal with, second to nothing, is housing. And if you go back to our Achieving Independence YouTube channel, we have a whole playlist on housing and housing issues, including using an ABLE account when it's possible to get around this. Here's the last one, is the resource test that determines whether or not you're eligible. So what's a resource? Anything that can be converted into cash for support is a resource. And if your resources exceed $2,000, and what it says literally on the first moment of the first day of the calendar month, you're not eligible for benefits that month. Okay, so the goal is to always make sure the resources are below $2,000. So for instance, you might be at $1,900 here, and then they deposit your SSI check, and so that's going to put you, pretty close to $3,000, not quite. Here, but what you have to do is spend it down below $2,000 before the first moment of the first day of the calendar month. By the way, these numbers were set in the 80s. If we had the most conservative cost of living increase, it should be somewhere around $28,000. I mean, for some of us, I can remember in the 80s, $2,000 seemed like an enormous amount of money. Well, it's not an enormous amount of money today. So anyway, now, there are some exceptions to this rule, and once again, if housing is your concern, and you might, once again, if that is and you're watching online, you might even email Amy and say that I would like a link to some of the housing videos, which you could find on our website. But a person who is on SSI or Medi-Cal can own a residence that they live in of any value, although they're going to have to somehow maintain that on their SSI. They can have all the stuff they want in the house here. So they can have big screen TV sets. They can have, there's no cost limit on household goods that they can have in the house and that kind of thing here. And before March 2005, actually, if you gave your child a sweater, they were supposed to turn themselves into Social Security. That ended 15 years ago, and let's pray that doesn't come back. If things are held for their intrinsic value, so if you're holding a Renoir, that's not going to work. Okay, but if you hold the kind of art that I buy, you're not going to have a problem in the world. A person on SSI or Medi-Cal can own one automobile of any value, although maintaining that automobile sometimes can be a real problem. They can also have any item related to their disability. And to finish this up, the SSI recipient can own an insurance policy with a cash surrender value no more than $1,500. That'd be a whole life variable life. If there are any financial people out there, you're probably scratching your head going, how would you make that work? This was written in the 80s. I don't think it made sense then. It doesn't make sense now. They can own a term insurance of any value. They can also own a burial plot or burial space or crypt of any amount, but they can only set aside $1,500 of their own money to get themselves into the plot. Now, by the way, we're talking about what the benefits recipient can own. The life insurance industry really loves special needs trusts, and there's a lot of legitimate times when insurance is sold to pay for this by the parents. That's not what we're talking about. We're talking about what the beneficiary owns. Now, one of the reasons oftentimes that you want to maintain your SSI, that if you maintain at least $1 of SSI, in most states you get what is called categorically eligible Medi-Cal or Medicaid. So you automatically get the Medicaid or the Medi-Cal. But that's not the only way to do it. I've seen people go to extremes to maintain that $1, and it's not always necessary. As far as Medi-Cal is concerned, we can definitely expect this program to change. It's a federally funded health program administered by the states, and the states might have different eligibility criteria. Surprise, we're in California. It's easier to join here than other states, but they will vary from state to state. It is important that you familiarize with the different programs and services available in your state. But in California, if you're not getting SSI-based Medi-Cal, then the rules change a little bit, and I believe the numbers, and I could be off, is that you need to have income below $1,200 a month. Okay, so we do get folks who will not be on SSI, or maybe will lose their SSI for any number of reasons, but in a lot of cases we don't want to give up the Medi-Cal, and that's something that we certainly want to do. What does Medi-Cal pay for? It pays for inpatient hospital services, outpatient hospital services, home health services, physical services, laboratory and x-ray services, transportation to medical care, although I don't know if I've seen that very often, but it says right here they do that. Dental care, which I'm not that wild about. And then a lot of services, if you're dealing with somebody with developmental disabilities that are paid for by the regional center, is paid for by Medi-Cal. Once again, and a lot of behavioral health programs are paid for by Medi-Cal as well. So in some cases, the Medi-Cal is extremely valuable. In some cases, it's not that big a thing. Let's go to our first entitlement. Social Security Disability is a national program for injured workers that have the requisite number of work credits in the Social Security system. Okay, so for instance, if you are still working, and let's say, God forbid, you were in an accident, and it left you in a situation where you were not able to work any longer, that's what Social Security Disability Insurance is for. It has no income or resource limits. Once again, you could win the lottery on that program here, but earned income may cause you to be ineligible because it has the same rules about eligibility for benefits, which is the substantial gainful activity rule, which is $1,220 a month, I believe. This is a program that's often missed, especially for folks with mental health, and this is why I wanted to bring this up. And by the way, it is not uncommon to have somebody that has a behavioral health issue who maybe didn't get on SSI or one of the programs until they were 24 or 25. That doesn't mean that the disability didn't begin sooner than that. It's not like having an accident and one day you're okay and the next day you're not. I mean, that happens in the movies. I haven't seen it a lot with all the years I was a psych nurse here, and doing the work I do. I'm sure it happens on occasion. So it might be if they were getting their benefits before the age of 22. If you have records if they were getting benefits, let's say when they were 25, it's incredibly likely the disability began well before the age of 25. And I'm going to show you why you want to keep those probably some painful records here to get them qualified for what is called childhood disability benefits. Benefits are not payable until a parent dies, retires, or becomes disabled themselves. Same definition of disability. Social Security is not affected, and we're talking about childhood disability benefits, is not affected by the child's assets, but the child's income may result in an ineligibility determination. Upon the disability or retirement of the parent, an eligible disabled child will receive an amount equal to 1/2 of the parent's benefit. And upon the death of the parent, the eligible disabled child will get an amount equal to 3/4 of the parent's benefit. Now, you only get to draw off of one parent's benefits, okay? So, and a parent is, once again, the legal parent. So you may have a situation where maybe mom or dad said, hey, I didn't buy into this, and disappear and never come back again. It's still their child, and they're still eligible for these benefits. The other thing with it is You get to choose whichever gets you the most. So as we're going to see, there may be situations where you get more from mom and then you get more from dad. Whatever gets you the most, that's what you're going to get. So on childhood disability benefits here's an example. Let's say that Helen has been disabled from birth and is receiving $943.72 in SSI monthly. Okay? Her father, Earl, retires and receives $1,400 a month, and she starts getting $700 a month. Math is pretty easy. That's 50% of what he's getting in Social Security retirement, presumably here. The receipt of the childhood disability benefits is unearned income, so they're going to exclude the first $20. It's called the $20 disregard, which meant a lot in the 1980s, but $20. I mean, really get your sandwich today. But receipt of the childhood disability benefits is unearned income, but it's going to reduce her SSI by $680 a month. So if we do the math, and assuming the math is right, she's going to receive $243.72 of SSI, and she's going to get $800 a month of CDB. If you add it all up, she's only $20 ahead, and you say, well, what's the big deal? But I'll show you what the big deal is in a minute. Let's go to the next example. Earl dies, and Helen begins to receive $1,050 a month. Helen's SSI is completely eliminated, right? Because this is real easy math. It'll just wipe it out. Helen will lose her SSI-linked Medi-Cal, and she may need to qualify under a different program. And under present programs, she should still be able to keep her Medi-Cal without a share of cost. She'll still be subject to the $2,000 resource rules and that kind of thing. And when you're used to living on so little money, $1,050 a month is a lot of money. I've seen it as high as $1,700 or $1,800 a month, and whereas many of us can run through that pretty quickly, when you're used to living on so little money, that will turn out to be quite a bit. And it doesn't have the same housing restrictions as SSI. Now, here's the kicker. If you're getting one of those programs for 5 months or longer, then you qualify for Medicare. Medicare is a federal insurance program for people over 65, but also people under 65 who've been receiving Social Security based on disability for 2 or more years. So she'd become what's called Medi-Medi. So she would get Medi-Cal and Medicare, and she would get a larger number of facilities that she'd be able to go to, because there's a lot of facilities who just won't take Medi-Cal here. And oddly enough, there are a number of facilities that just won't take Medicare, but only take Medi-Cal, just to drive us all insane. So you can be eligible for both, and Medi-Cal is always the payer of last resort. So after we went through all that, let's talk a little bit about what you came here to hear about, which is special needs trust. And what we're talking about today is the estate planning special needs trust, which Social Security calls a third-party trust. Now, there is a second kind of trust here, which is when somebody gets like a personal injury settlement or that kind of thing. They're commonly called Medi-Cal payback trusts. That's not what we're talking about today. So a little basics about special needs trust. The Social Security Administration defines resources for SSI as cash and any other personal property that an individual owns or has the power to convert into cash, or not legally restricted from using for his or her support and maintenance. So if the SSI recipient does not own the asset outright and is legally restricted from directing access to those funds, those assets are not considered a resource for benefits purpose. So that's the foundation of special needs planning. So a special needs trust, and just even backing up, all a trust is a contract. There's living trusts, which we certainly do. There's charitable trusts, there's foundations, there's all sorts of trusts out there. Today we're going to be talking about special needs trusts, and it's a special kind of trust where the trustee has sole and absolute discretion over the assets in the trust, and the beneficiary has none. Therefore, it's not a resource, okay? In essence, it's what's called a Spendthrift Trust, okay? So, which is a Spendthrift Trust is where the trustee has sole and absolute discretion and the beneficiary has none. It was really popular until women started getting their rights, because, of course, in the 1700s, you would never leave a woman money. What would she do with it? Here, you would put it in a trust and have somebody watch over her. Now, those are really, that stopped about 300 or 400 years ago. But that is the concept. They're called Spendthrift Trusts. So by directing the assets that are otherwise intended for the individual in a special needs trust, you're preventing those assets from being counted as an available resource, thus preserving their eligibility for SSI, Medi-Cal, IHSS, and similar programs. Now let's go back and look at a piece of this. The trustee has sole and absolute discretion. What does that mean? It means that your loved one could make the most reasonable request under the sun, and the trustee must have the power of saying no, and I don't have to give you a reason, right? Here, so when we start talking about choosing a trustee, you probably better be pretty careful about who you're going to choose for that, okay? Now, this is what's called the Pom Site. So see where it says SI 01120.200B3. Those are what's called a Pom Site. It's called the Program Operation Manual System, and these are directives to Social Security workers when they come up against a situation. And by the way, Medi-Cal rarely makes rules that are more restrictive than SSI. So here's what they say. A supplemental needs trust, which is the same as a special needs trust, is a type of trust that limits the trustee's discretion as the purpose of the distributions. It typically contains language that the distribution should supplement but not supplant sources of income, including SSI or other government benefits. Now, what you'd see when you actually see the trust, it has another clause that says, yes, but, and let's use Deni-Cal as an example. Even though Deni-Cal may be available, and maybe your county has a terrific Deni-Cal program, my county doesn't, that we can say, that's okay, we're going to send our beneficiary to a real dentist here, and we'll pay for that privately. So it doesn't mean that we have to follow these rules absolutely strictly, and there's lots of cases where maybe we're better off causing a reduction or even an elimination of a program if it makes sense to do it. So a third-party trust is established by somebody other than the beneficiary as the grantor. The grantor is the person that creates the trust. That's you folks out there. For example, a third-party trust can be established by a grandparent for a grandchild. In my case, we've established one, my wife and I, for our niece who has Down syndrome here, and a grandchild on top of that. So it doesn't have to be a parent. It could be anybody but the beneficiary. It could be a brother or sister. It could be a friend. It could be a church. It could be anybody. A special needs trust can have a lot of latitude, so you can have multiple beneficiaries in the trust. You can tell the trustee that they can turn the trust on and turn the trust off. Here, you can write virtually anything in that trust here, and when you pass away, you can leave it to anyone you like, except you can't leave it to the drafting attorney because the state bar really frowns on that kind of thing. Okay, so, but you can use it to leave it to a nonprofit organization. And once again, NAMI would be a great organization to leave it to. So, for the rest of this, let's talk about the process of putting the trust together and how to get ready. Whether you work with our office, or as I like to say, if you want to work with the lesser law office, that's certainly fine. Here, but this will help prepare you for before you sit down with the attorney. And as we're going to go through later, with our fee schedule, we actually give a $500 discount to folks that have attended the workshop here, either online or in person, and have followed the instructions we're going to have in a bit. And the reason is that we find the folks that watch this workshop are better prepared than folks who just walking off the streets who are going to have questions about what's a special needs trust, what can it do, and who should be the trustee. Hopefully, this will answer a lot of those questions. So the process of creating a special needs trust can seem daunting, but by approaching this in a step-to-step process, it can be a whole lot less overwhelming. By following this approach, the special needs trust will be better, it'll better meet your objectives, and it won't be as horrible an experience. Okay. Now, when we do begin with this, I want to introduce you to two key members of the Dale Law Firm. I actually don't do drafting. Mostly what I do is I do advocacy here, and I do a lot of public speaking. The drafting team here is Jennifer Stenberg here, who has a disability rights advocate in her own sense. She's basically been involved in disability work her entire life. She worked for Congressman Miller here for a number of years as a special needs expert, and also worked for a leading ADA lawyer for a number of years. And she's very skilled herself, and she is also on a number of boards here. So when you're working with Jennifer, you're not getting somebody who's going to do a lesser job. In fact, what you're going to find is she's less chatty than I am, and so you probably get out of there faster. With that, a lot of this work is done with Lysandra Wilson, our senior paralegal, who actually has a JD on top of that. And so if you're doing this work, they pretty much work as a team, and we'll talk about how that works. So here's our four-step process. The first step we're going to go through is you need to clearly express your intent in your document, in your trust and related documents. And we're going to go through this in detail. The next step is you need to choose a management system and team to carry out your intent. The third one is to develop a funding plan to fulfill your intent. So you can have the best trust in the world with a great trustee, but if you don't put something in it, it's not going to do very much at all. The last one, and this is really common with disability because you're actually never done here, is that you need to update the trust here, review the whole process periodically, not just during your lifetime, but for the lifetime of the trust, okay? These become living, breathing documents, and they need to adjust as things come up. So let's talk about expressing one's intent. And once again, in the present guide, it's in Chapter 8. It may be in a different chapter in the next version. So, disability is a life-changing experience. Providing proper supports for a person with a disability is not an intuitive thing. You know, if you're a parent of a child with a significant disability, do you remember what your life was like before your child had that disability? And you know, the fact is, disability is a life-changing experience. Many times for the good, many times for the bad. But the problem is, in a lot of cases, if you choose somebody who's going to be overseeing your loved one's care and they really don't understand community programs or the needs of folks with disabilities and the things you probably learned in dealing with the fact that you have a loved one with a disability, they're probably going to be ill-equipped to do this without an enormous amount of help. Now, there's a lot of exceptions to that, but that's basically how I see it. So one of the primary duties of a trustee of any trust is to comply with the intent of the grantor, the person creating the trust. A bare-bones trust that only says preserve my loved one's eligibility for SSI and Medi-Cal is going to lack the proper directions that the management team needs in order to carry out their duties. Without proper documentation, the grantor's intent and objectives here, the trustee will not be able to understand what it is you wanted to do with this trust, okay? So really, you need to be able to communicate what is it you want that trustee to do. Now, one of the things we always have to be careful about is that there's a large amount of abuse and neglect of folks that are disabled in the community, depending on their ability to self-advocate. And the single most effective way to prevent abuse and neglect is to encourage the beneficiary to be involved, as involved as possible in a variety of community activities of their choosing. The more your disabled loved one is involved in a circle of support, such as a religious community, a social club, a job, a neighborhood organization, anything along that line, the less likely that he or she is going to be subject to abuse. Isolation is the devil, and that's when things really get bad. So, what you want to do is clearly state your intent in the event that a future trustee who has no idea who you were is administering that trust. It's going to be clear what's expected of them. A bare-bones trust can only accomplish limited objectives. So the way we do that is And you'll see when you go through the intake sheet, it's going to ask you questions about what kind of housing is acceptable, what kind of social programs are acceptable, what kind of hobbies, what is there a concern, or is there something you'd like to do as far as vocational needs and that kind of thing. So generally we have one page that will have very broad information about your child, and these are generally things that are never going to change. Tied to that is a letter of intent. I like to call them journals of intent. And a journal of intent, you can do more detail. For instance, it could be that maybe your child had a terrible reaction to phenothiazines, and it could be that, like, never give him or her Haldol or Thorazine again because they had a terrible reaction here, and that sort of thing. You might put in what kind of treatments helped. Any guidance you can give them on how to carry on your advocacy and the support that you've given that child is going to really help the trustee to have some idea of what they're supposed to do. Think of the journal as ongoing, as an ongoing record of the beneficiary's needs. Let's go to the next need. Okay, the next part, which is the quest for the ideal trustee. Now, I'll just mention this before we get into this. I am the trustee. I'm the temporary trustee of the Golden State Pool Trust. I think it's been about 9 years, and in about a year or two, I'm probably going to rotate off. But I've been the trustee of 250, give or take, beneficiaries for 10 years, and boy, has it really opened my eyes here. Now, I would submit to you, because I'm an attorney, and so definitely I'm full of myself here, that I'm a pretty good trustee. But if I were to say that I meet all these different items that we're looking for in a trustee, it would mean that I'm either delusional or lying to you. Okay, so first off, because the trustee has sole and absolute discretion, we're looking for the trustee or the management team to make sure they're going to use their discretion in the best interest of the disabled beneficiary. Okay. They need to understand public benefits and keep up with changes in the law, and it actually kind of comes under the advocacy part as well here. And it doesn't mean that the trustee has to be a benefits expert, because there are consultants that can help with this, but they need to really understand the benefits they're dealing with. For instance, you might be in a situation where the trustee's concerned about paying for shelter because it would cause a loss of benefits. But if it means the difference between living in some place you wouldn't have a dog live in and having your child, live in a decent place, a lot of our clients will opt for try to buy them or try to provide them with a decent place. If they're on SSI, sure, it might cause a loss of the SSI, but there's other ways to maintain the public benefits. So sometimes it's not just understanding what the benefits are, but it's also putting a value on them, because there's times when the benefits are helpful and there's the times when the benefits are hurtful. Somebody who's going to wisely invest and conform to all statutory fiduciary requirements. All trustees are required to do to invest the funds in what are called prudent investments. Okay, here. But think of it this way. Let's say that you wanted to be equal with your children, which is almost impossible because children are not equal, disabled or not. But let's say that's your goal. And what you're going to do is you have $1 million you're going to allocate here. And let's say you're going to leave $500,000 to your typical child, not a great term, and $500,000 to your child's special needs trust. Now, if your typical child messes up with the investments and loses the money, hey, what the heck? They have a lot more options than your child with a disability. If the trustee makes speculative investments and loses the money for your child with a disability, you're never going to see that money come back unless there's a lawsuit. And so you need to make sure that somebody's really on top of that, doing proper investments, and that would be including keeping an eye on the taxes. Somebody who would understand taxes. I happen to have a master's in tax, which is kind of bizarre if you think about it, but I do here. And there's a lot of fascinating things you can do as far as using this as a tax tool. here to reduce taxes here. So certainly we want to get all the best tax breaks we can, as well as get a good result for their advocacy and their public benefits. This is really important. We are in the 9th region of the Social Security Administration. If your child is getting SSI, Social Security has committed that they're going to review every expenditure in every special needs trust. In the Golden State Pooled Trust, we get about 2 to 3 requests a week from Social Security. Here, I'd say that about 60% of beneficiaries actually get audited, but the number is very high. And it's absolutely impossible, imperative, that if they get audited by the Social Security Administration, that we've recorded all those distributions and can account to Social Security what it's for. Okay, so the other part of this, and a lot of trustees will work with what are called care managers, or we have another exciting program we're working in the San Francisco Bay Area that will be expanding, called the Life Passage Planning Program. But somebody can provide advocacy and prevent abuse. Now, sometimes that can be what's called natural supports. It could be family members, and if you have somebody who's really in tune to that, well, we certainly wouldn't want to stop that. More often than that, we're going to hire a professional care manager that will go out and check on your loved one from time to time, or get our case management through the Life Passage Planning Program. If that's something you're interested in, once again, mention that in your email to amy@dalelawfirm.com. Here's the one that I would have a hard part with, is you got to be out immortal, okay? So I have this very large conference room table, which breaks out for this, and I have had people sit at my conference room table and want to name their 6 and 7-year-old nieces as the trustees of their disabled loved one. That's insane. What they're looking for is who's going to outlive my loved one. Well, the fact is, that's a very difficult thing to do. And even if you do choose someone, we have to plan for continuity. So how do we find this person? And here, first off, they don't exist, right? So what I'm going to be doing over the next few minutes is I'm going to go through some models that we recommend. Not that you have to stick to those models. You'll also notice that I'm going to strongly suggest you don't make a sibling the trustee of their sibling special needs trust unless they really, 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 really want to do it. I do this program with NAMI from time to time called Why You Shouldn't Make Your Daughter the Trustee of Your Bipolar Son Special Needs Trust. It's not a good idea. What did she ever do to you in the first place, right? I mean, it's hard for any sibling to be in charge of another sibling. Add behavioral health issues on top of that, it can be a recipe for disasters. Now, there's huge exceptions to that. So it's one of those things that if you're considering doing that, we might put them in as the trustee, but have a clause that says they can delegate that trusteeship to somebody else. Because I think a lot of folks head into this with the best of intentions, and it doesn't get difficult for things to go awry. Now, the way we find our ideal trustee is if you take that list and if you divide it up. How you divide it up almost doesn't matter. So if we put the advocacy in one sphere, okay, and that would include in this case the discretion and also public benefits. Once again, I count public benefits as kind of an advocacy portion of this, because sometimes it's making the decision about whether the benefits are worth keeping or whether they're causing more damage than good, okay, and also provide advocacy and prevention of abuse. This is where the care manager or the life passage planning program or something like that would come in. With that, we might have for the financial, we might have a financial advisor here working with the trustee who can wisely invest and conform the statutory requirements and keep in mind what those, the taxes. And once again, we want to get a good tax resort. So on the accountability side, we need somebody who's going to keep really good books, has insurance, and be immortal. So let me show you how this plays out. These are just suggestions, okay? By the way, let me mention this. when you are coming to any attorney, but especially if you're sitting down with Jennifer and her drafting team here, you're not buying a document, you are buying the experience of the law firm, okay? So as you sit down with Jennifer and her drafting team, ask her questions. She's seen hundreds, if not thousands, of situations similar to yours. She also gets involved in the administration of the trust, and she can give you some pretty good information. And you may have a situation that makes sense to you, but she'll be pretty frank with you about whether in her experience this is likely to work or not work. Okay? So in this case, the trustee is going to manage the funds, keep the makes the distributions, does the taxes, and keep the records. Here, the trustee is, and the trustee in this case, when we're using a professional trustee, it could be a corporate trustee. So we use Wells Fargo Bank often, Fremont Bank and Trust. There's West America Bank. There's a number of banks who've specialized in doing work with special needs trusts. And so, part of this is, when you're looking at whoever the initial trustee is going to be, certainly you want to use folks that have experience and we've had good experience with. The trustee is directed by an advisory committee, which gives guidance on the distributions, can amend the trust, and this is really important, can replace the trustee. It doesn't make sense because the way these things last, you may have a situation where maybe you even have a decent trustee, but if it's just not working between the trustee and the beneficiary, maybe the advisory committee is going to say, thank you very much, we're moving our business elsewhere. By the way, in California, we also have what are called private professional fiduciaries. We have lots of private professional fiduciaries in California. And many of the folks we work with are used to working with special needs trusts. We especially like finding professional fiduciaries. These are private licensed trustees. Here, we especially like private fiduciaries that work with folks with behavioral health issues. It can include a care manager to assess the needs of the beneficiary and give guidance to the team. This is where, once again, oftentimes we'll suggest that at least once a year, maybe more often, it depends on your child's needs, we'll have a professional care manager come out and check from time to time here, especially if there isn't family members that are checking on them on a regular basis. But they'll often pick up things like they're usually very good about picking up side effects, for instance, for medications. That maybe weren't picked up before. They're also very good about picking up clues when they're in a situation where they might be subject to abuse and neglect. I will tell you the care manager is an incredibly important part of the team. Okay, and for those of you NAMI chapters that are watching this here, maybe having someday a care manager come and talk to your group is a really valuable thing to do. I will tell you, that adds a really special side to this. The next model, and I'll just put this all up, is very similar. The trustee is going to manage the funds. The care manager is going to interact with the beneficiary. But instead of having a committee, we might have a trust protector. Now, we've had a number of situations with folks, usually with a severe mental illness, oftentimes a bipolar disorder, who will just hound the trustee or hound the care manager until they get what they want. In this case, what we're going to do is the trust protector technically has less role. They're not involved in the day-to-day operation, but what they are involved in is they can adjust the trust if laws change, and they're certainly going to change. And they can also replace the trustee if that's necessary. Now, this is a good role for a family member, okay? So once again, if you're thinking about having a son or daughter involved in the trust, this is almost a better role. Now, we have some folks that'll say, I want to start off with a son or daughter as the trustee, but if it's not working out, they can assign somebody to serve, and then they become the trust protector. And by the way, a trust protector can do a fine job even if they live across the country, if they have the right information in front of them. Now, for most of those programs, you're going to need a minimum of probably $300,000 or $400,000, and depending on the trust you use, because for instance, Wells Fargo has $1 million minimum U.S. Trust has a $5 million minimum here. That's not a trust we use quite a bit. And it might be that you'd go, boy, I would really love to make, hire a corporate trustee that has a lot of experience. But all I have is I'm going to leave the use of my house for my child and maybe $100,000 on the side. In that case, you might have trustees or co-trustees, but then you would narrowly tailor that trust, because in that case, your focus is going to be making sure the roof doesn't leak. Okay, one of the biggest problems of you leaving houses for a person with a disability to live in is if you don't leave money for upkeep and taxes and things like that, eventually you will lose the house. We probably evict 2 people a year, and it's not a pleasant thing because the trustee has simply run out of money and they can't maintain the house or pay the taxes. It's a very unpleasant thing. I will tell you, part of this is if you can get a person with a disability, no matter what kind of disability it is, into a safe and secure housing here that they can live in long term, that is half of the battle right there. The last model I'll mention real quick is this. Okay, and we have more materials on this, is you might have an individual trust here that is managed by a pooled trust. Okay, now what's a pooled trust? So there are many pooled trusts in California. I put up Golden State Pooled Trust, well, that's the one I'm trustee of. But there's Plan of California, there's the JLA Trust here in Los Angeles, and there's the San Diego Community Trust, all very fine trusts out there. What a pooled trust is it manages the funds, it keeps distributions and records. They'll tend to be call centers, but what they'll do is they'll oversee the distributions. They share their resources amongst hundreds, in some cases thousands of families. So for instance, oftentimes they'll include a care manager or advocates at a lower cost because they're able to spread that cost amongst a broad group of people. Ideally, a pooled trusts are accountable to the family or a circle of support of the beneficiary. So once again, we have all sorts of materials about how to do that, but it's not uncommon for us to say that I want the trustee upon my death to be, let's say, the JLA Trust or a private professional fiduciary, corporate trustee, or pooled trust of either the trust protector or advisory committee's choosing. That way you get the benefit of the pooled trust, but if things aren't working out, you have the ability to move it. And the whole area of administering special needs trusts, it's a relatively new area of law. It's changing all the time, and there may be services that are going to be provided by some trustees that we wouldn't even conceive of now. So you might even have a trustee who's doing a really good job, but if there's another option that's getting you better results for less money, why would you not want that? Okay, and so we want to enable the trust protector or care manager in this, the trust protector or advisory committee here to be able to do that. So we're almost there here. So funding your trust, as I said, consider the trust as the vehicle, the trustee as the driver, but if you don't put some fuel in this thing, it's not going to do very much at all, and it certainly won't meet its goal. Here, one of the biggest mistakes we see in estate planning in general is not making sure the trust is fully funded. What does fully funded mean? That either the assets are going to get in the special needs trust through a beneficiary designation, or the assets will be owned by the trust. Now, by the way, if you have a financial advisor you're working with, you certainly want to include them in the process, and they can help advise on what assets should go in the trust. But they can also work with you. A good financial advisor is going to make sure that here that your assets are properly titled, and that's really, really important. Here's the last step, which is review and update. A question I often hear is, how often should my child's special needs trust be reviewed by my attorney? And I'll give you the lawyer's answer to everything. it depends because we're kind of trained not to give straight answers, but there's a reason for it. As unsatisfying as that might be, here's some information that can help you. We actually have a video on our website here and also on our YouTube channel called a self-check for updating my child's special needs trust and an updated self-review for reviewing my living trust. What we usually suggest, the other thing I did is I did write this article not that long ago for the Special Needs Alliance, which Jennifer and I are both members of and very active with, which has to do with reviewing the trust. So, if you begin with an annual review that you undertake yourself with the assistance of your financial tax advisor here, and we usually suggest once a year, maybe every other year, but this isn't something that should sit on the shelf forever. Once you've performed that self-check, you'll be able to determine if it's really time to update your estate plan and your special needs trust, okay? Because a lot of the things usually that you're trying to focus on is, have there been any changes in my child's situation, any changes in my financial situation? Are the folks you named as trustees correct, or as advisory committees and all of that? That's usually what you're trying to review. So for the last segment of this, let's talk about the process we use at the Dale Law Firm. And it's kind of a 4-step process. You might see that we're into process. The first one is going to fill out the intake sheet before the first appointment. Part of this is, that's good manners, and secondly, if you do that, then you'll qualify for the discount that is in our fee schedule. And the fee schedule changes, so we'll forward that to you, and of course it's subject to change. Meet with Jennifer and sign the representation, and we usually take 50% down. And then what happens is she'll work with you, do the intake, and then within a week or 2 or 3, depending on how backed up we are, she'll provide you with a PDF draft of the document, most with highlighted segments you need to go through. Most of our clients do that at home. You can do it here, but what we try to do is really help you focus on what really needs attention. There's an awful lot of boilerplate in these trusts, and quite frankly, I can't tell you it's not important, but digging through it word by word is not really a good use of time. So what's unique about planning for a loved one with a mental health diagnosis? One is currently there's fewer programs unlike those for folks with developmental disabilities. If you have a loved one with autism, then there's what's called an entitlement to all sorts of services. In California, for mental health, there is no entitlement. It's common for the beneficiary to have wild swings in circumstances and behaviors, okay? So we need to be able to account for that and be able to deal with, the good times and the bad times. Oftentimes, this is where the care manager will come in here to try to detect those things as early as we can and try to intervene. It's also often more difficult, not impossible, to find trustees or advisors. Okay, because let's face it, these are oftentimes the toughest of the tough, although we're able to place most of these trusts with somebody. And we want not just somebody, we want somebody who actually understands mental health and cares about your beneficiary. Family dynamics can be really challenging. That's not something we need a long dissertation on. But, once again, mental health here can often be really challenging with family dynamics. And this is one of those things that if you're doing family meetings like that, and that sort of thing, you need to be really frank with folks about whether or not they're really interested in, being that advocate for their brother or sister, or if it's something they're not really into, and then respect what their wishes are. The worst thing is to guilt them into taking this position, because some folks, they just want to be the brother and sister and don't want to be their sibling's keeper. Many times too, is that many folks with mental health have substance abuse, or it could be self-medication, and that can be a common issue. So, there's a lot of challenging things we're dealing with here. Also, circumstances change. people get better, people get worse. So in the trust, here, we want to be flexible. We want to make sure we don't back ourselves in the corner here by making demands that one thing or another happens. So you might make it a wish, not a demand, because the trustees will do the best they can. You need to be realistic, okay? And you need to provide your loved ones, protect your loved ones in many cases on taking on responsibilities they're not prepared for. I'm going to skip this slide. So the other thing we often look at, and this is something that I have seen that a decent care manager, or we have this new program called the Life Passage Planning Program, which provides a different kind of care management, can make the difference between whether the trust is going to function or not. Having somebody with a social service background that understands mental health and understands programs in the community is really, really important. Because most trustees, they're not social workers, they're fiduciaries. Their job is to make sure the payments are made, make sure we don't lose our benefits and do all of that. But they're not really equipped to deal, in many cases, with a behavioral problem that somebody with a behavioral health diagnosis might have. These are all individuals, and it really depends on the individual. So I know I'm painting a broad stroke here, and you got to apply it to your situation. So in our first step, once again, what Amy will send you here if you email amy@dalelawfirm.com is she'll send you an intake sheet. It's about a 12-page intake sheet. If there's questions in there you don't understand, don't worry about it. But once again, it's really helpful. In fact, we insist that before you sit down with Jennifer and her drafting team, that the intake sheet is filled out, okay? When you meet with Jennifer, and the meetings last for anywhere from an hour to 2 hours, there's no set amount of time. So you would come in and sign the representation agreement, and we take 50% down, whatever it is we're doing for you. So we might be just doing the special needs trust, or we might be doing a living trust and a special needs trust. Once again, what we do is we take 50% when we begin, and 50% when we're done. Jennifer will meet with you either in person or by phone and answer any questions you might have, and we'll design the trust. And once again, it should be interactive. Your job is to teach Jennifer about your child and your child's needs. Her job is to take that information and teach you what the trust can do, and then make sure that it's recorded in the trust so it can achieve what your goal is. She will then begin working with the drafting staff to complete the initial draft of the documents for your review. So this is what the this is what the intake sheet looks like here. So you certainly want to read it before you sign it here. And then as far as the trust is concerned, the next step after you meet with her is to review the PDF draft of the document. Usually that's done by phone, so usually what happens is that's sent to you, giving you some time to go through it so you can come up with your own questions. Generally what we'll do, as we see in this draft, the parts we think you should review, we'll put it highlighted. It doesn't mean you can't review the entire trust. But usually the questions you're looking for is, who's going to be the trustee? Does it really capture what you want this trust to do? Do you have the right management system and the right trustees in there? And do we have the right people named as being beneficiaries when your child passes away? That's usually the biggest part that we're dealing with. You review your trust draft. Jennifer will address any questions that you will then finalize the documents for signatures, normally in the office itself, but it is something that we can do by mail as well. So if you're living outside of the area and it's just too far to drive, doing a special needs trust is certainly something that you can do over the phone. A living trust gets a little bit more challenging, but we can do that as well. The last step is your document can be signed either in the office or remotely. So this is what the front page of the trust is going to look at. And our fees subject, which haven't changed since March 2019, basically for a special needs trust, if you, once again, if you attend the workshop, well, if you don't attend the workshop here or watch this online, here we charge $2,500 for the special needs trust. Or no, we charge $3,000 for the special needs trust. But if you, once again, watch the program, we'll drop it down to $2,500 flat fee. For a revocable living trust package, the two of them together, if you're single, we'll do the whole thing for $3,500. And for a that's just if we're doing the living trust. And then once again, for a couple, if we are doing the living trust and the special needs trust, our rack rate is $5,000, but we will do it for $4,500 if you watch the video or attend the workshop. To confirm the fees, you should contact the Dale Law Firm. With that, that covered the basics of what I wanted to cover here. Amy, do we have any questions out there?
Yeah, we have questions. Did you want to ask?
Why don't we start with our audience, and the microphone is right there, so if you can speak towards the microphone, that would be great. Anybody have a question out there? Amy, give us a question.
Okay, I have a number of them. The first one is, once a property is in the irrevocable trust, how could financing ever be done to maintain the property?
The trust at that point will become irrevocable, and it could be very difficult. There are programs that do that. There are lenders, they tend to charge more. So I just saw a lender who's charging 8%. If it already comes with a mortgage, there's a thing called the Garment-St. Germain Act that says they can't call in the mortgage as long as we keep making the payments. But getting a future mortgage could be more difficult than doing it if it were not in the trust.
Okay. One of the things you said at the very beginning of the webinar was about your experience in Texas. Was that with respect to mental health?
That was with respect to mental health. Actually, it's kind of sad to say because I actually teach in Texas once a year, and they've done exactly the opposite of what California has done, which is probably not unusual for Texas here. They put all their money into mental health. It's not to say it's an ideal system, and put very little into developmental disabilities. We put all of our money into developmental disabilities, very little into mental health. If you were thinking of going to Texas, you probably would want to check with somebody in Texas. Probably NAMI, Texas would be a good place to go to really understand those programs. But they seem to be more liberal with attended care programs and that sort of thing. It's not like they have a huge amount of programs, but they have more programs than we do.
Okay, the next question is related to benefits. Let's say a beneficiary or someone with a disability has, just getting SSI, and they're getting their $943 a month, and they are lucky enough to get a Section 8 voucher. So they get this apartment and they're paying 30% of their income. And then, 10 years later, both of their parents pass away, and now they're getting CUV. And so they're getting much more than $943. They're getting greater than SGA. So are they all of a sudden going to be kicked out of their Section 8 housing?
They wouldn't be cut out of their Section 8 housing. Section 8 or HUD is what I like to call the bad boys of disability benefits, because it's almost impossible to predict what they're going to do. This is the other sad thing about Texas. It's easier to get HUD or Section 8 in Texas than it is in California. I mean, we have waiting lists for waiting lists, as you well know. But here's the thing that happens. There's a bunch of erratic rules when it comes to counting distributions from a special needs trust. One set of rules, which has been kind of accepted for some time, is any regular reoccurring distributions will count towards the 30% rent, right? So if an example would be, let's say we paid somebody's cell phone bill for $100 a month every month, then their rent would go up $30. Some programs actually say that's way too complicated and we're not going to count anything, whether it's reoccurring or not. And most programs, that's what they're doing now. There are some programs like San Mateo and Santa Cruz where they count every distribution, whether it's recurring or not. It's erratic. It changes. My experience has been that when they do start pulling out these rules here, usually they're pulling out these rules because they have a tenant that's a problem and they're looking for any way to get rid of them. Once again, what's going to happen with your housing authority in your specific situation, it's a wild guess. We're hearing through the grapevine that HUD is looking at renewing their handbook and being more specific about special needs trusts. But right now, we really don't know. And I realize if you have somebody who's getting HUD or Section 8, maintaining that eligibility is really important. We've only had one case when somebody lost in 30 years, lost their HUD, and that was somebody with a severe bipolar disorder that had wild mood swings, and their motivation really wasn't the trust. They just wanted to get rid of it. That's what I think.
But there could be a situation where someone doesn't even have a special needs trust. All of a sudden, they just are getting, $3,000 a month of CBB when they used to get $943.
I'm not 100% what they count because they have some disregard, so I can't give you an exact number. But that won't cause you to lose the Section 8. It may cause you to pay a higher share of rent. The general rule is HUD or Section 8, you pay 30% of your countable income.
Another question was, you talked about audits from Social Security.
Yes.
Does the trustee get that directly?
Not usually, and that's a problem. Usually it's going to go to the beneficiary or the rep payee. And so it's really important that the trustee be in touch with the beneficiary or rep payee here, because it's the trustee who's going to have to provide the information. Unfortunately, since they're not the benefits recipient, they don't get notice directly. And so the important part of this, and I have to tell you that for folks that are on benefits, they're terrified of losing the benefits. So what you want to try to, oftentimes they'll take any letter from Social Security and just shove it in the desk drawer and not open it. We have to make sure that somebody opens up those letters, because we could have a problem that's festering and won't know until they actually cut off their benefits.
Okay, and the last question is, how new are pooled trusts?
As far as we can tell, the first pooled trust came in the late 70s, early 80s. Nobody can pinpoint the first one here, but let's say it's 1970. They were codified in 1993, but they were around long before that. So like the Ark of Indiana was one of the first trusts. There's a trust for a Jewish community that's in New York that's been around for years. Okay, so those were the pioneers. But, for the most part, they've only really been a viable alternative for 30 years. They're a great alternative. Here's my only problem with joining a pooled trust if you do it through the traditional way. The traditional way of joining the trust is doing it through a joiner agreement, okay, which is basically a contract you sign to join the trust. And you get an account, you don't get a trust. But here's the problem. What if for some reason the pooled trust that you chose is not the best answer? Well, we don't have the mobility. We don't have the ability for someone to say, thank you very much, we're moving our business elsewhere. And for me, the whole thing about these special needs trusts is that we're doing long-term planning. We're here for the long game. And, we go back to Kathy. If she were 17 years old when her parents passed away, and I recognize that there's health issues for folks with schizophrenia, but let's just say we're lucky and she doesn't. Statistically, she's supposed to live for 70 years. Think of the enormity of that job. And think of the enormity of naming a trustee who's going to be there for 70 years. It's impossible. That's why we recommended checks and balance system. My preferred way to work with a pooled trust, even the Golden State Pooled Trust, is name them as the trustee of your individual trust, and then otherwise treat them like anybody else. But have with that trust a trust protector or an advisory committee that if they don't feel like the trust is the best option for your loved one, they have the ability to move it to another pooled trust, a professional fiduciary, or whatever options you think are best. Okay? Any last questions?
No, that's it.
I want to thank you so much for watching today. I mean, there's no way possible we could have covered everything. As the old proverb, Chinese proverb says, may we live in interesting times. Well, we certainly are living in interesting times.
Well, I got two more questions.
I just want to make a pitch before we take our last two questions here that NAMI, the National Alliance for Mental Illness, is probably the most important advocacy group that serves persons with mental health disabilities. And so in your estate plan, if you can even leave them a minor token, they'll make very good use of those funds, and it will serve so many people with mental illness and advocacy and that kind of thing. It's a good investment in our community. Last two questions, and then we're going home.
Okay. My disabled adult child is transgender and hasn't changed her name legally. Do we need to wait until she changes her name before doing a trust?
I have had a lot of questions. And that's a new one. And being that we're in California, I'm surprised this is the first time I ran across it.
No.
The same thing would be as if you had a daughter that was marrying somebody that was going to change her name, that sort of thing.
And gender.
And well, once again, we're making a few more changes here.
Yes.
If it isn't going to be long before the name change, or if you know what it's going to be, you might say, I know these are always sensitive issues. You might say this is, for Jennifer, aka Bob, whatever you're doing, however you're doing it. I know these are really sensitive because a lot of folks that are transgendered, they want to cast that off, and want to be known by their new choice of gender. I think you deal with that on an individual basis.
Okay. The last question was a follow-up to the one about financing the property.
Yes.
And it was, do you have any suggestions to prevent this issue and still protect the assets after the death of the trustee? I'm not exactly sure what that means, but.
I can see that two ways. Okay, I'm assuming we're not dealing with loans, because of course the loan's going to have to be paid back, right? But there are some situations where if you're looking at, this is where you might want to look at our housing videos. We have hours and hours and hours of housing videos. And you might look at that and, make your own decision here. If you do decide to leave the house to your loved one with a disability, you still might want to think about putting it in a third-party trust. And if you're not going to do that, put it in a living trust. And here's why. California has a lien for any Medi-Cal you've used after the age of 55 by any property that goes through probate. Let's say that what you want to do is, despite a lot of the things we may suggest to you in our housing videos, that you'd probably be wiser to put it in a third-party trust. Let's say you don't want to do that. At least put it in a living trust, because a living trust will avoid probate. And that way, if they live into their 60s, 70s, or 80s, there won't be a whopping lien when they pass away. I think a third-party trust is the better way to go. And I would suggest to this viewer that you email amy@dalelawfirm.com, if I mentioned that a couple of times, and ask her to send you a link to our playlist on housing. And I think a third-party trust it's a good asset protection tool. For instance, if your child gets sued, they don't own the house, so so it won't be subject to your child's debts. And how are we doing?
Right.
With that, I'm going to give you one last chance. With that, I want to thank you so much for coming today here. Please email here amy@dalelawfirm.com, not just for the materials, but also to get on our mailing list for future programs that are coming up. One thing that we will be covering probably in the next 6 to 8 weeks is a program called the Secure Act, which has to do with retirement plans, where there's been an enormous amount of changes. With that, I want to thank you so much for watching, and happy advocating.